matter of Federation of Governing Bodies for South African Schools and member of the Executive Council.
Places, I appear for the respondent, saying an accountant, Michelle R. Thank you.
Chief Justice, I'm Frances Hopton. I appear for the amicus curiae Equal Education.
Thank you. Teaching and learning are as old as human beings have lived. Education is primordial and integral to the human condition. The new arrivals into humankind are taught and learn how to live useful lives, fulfilled lives. So education's formative goodness to the body, to the intellect and the soul has been beyond question from antiquity. And its collective usefulness to communities has been recognized from prehistoric times to now. The indigenous, ancient African wisdom teaches that tuto, kilisedi, lasachaba, imfundo, isibalo. Education is the light of the nation and recognizes that education is a collective enterprise, observing that it takes a village to bring up a child. Of this, Aristotle said, education is an ornament in prosperity and a refuge in adversity. Immanuel Kant asked, how then is perfection to be sought? Wherein lies our hope? Asked Immanuel Kant. And he answers, in education and in nothing else. Karl Marx instructed that education of all children, from the moment that they can get along without a mother's care, shall be in state institutions. Mahatma Gandhi, on the same subject, had this to say: if we want to reach real peace in this world, we should start educating children. On the other hand, Helen Keller reminds us that education should train the child to use her brains, to make for herself a place in the world, and maintain his rights even when it seems that society will shove her into the scrap heap. Utata Nelson Rolihlahla Mandela explained the value of education in these words: education is a great engine of personal development. It is through education that the daughter of the peasant can become a doctor, that the son of a mine worker can become the head of the mine, that the child of a farm worker can become the president of a nation. It is what we make out of what we have, not what we are given, that separates one person from another. Kofi Annan was not silent on the subject either. Education is a human right with immense power to transform. On its foundation rests the cornerstone of freedom, democracy, and sustainable human development. Malala Yousafzai eloquently stated, There are many problems in the world, but I think there is a solution to all of these problems, and it's just one. It's education. The Holy Bible warns in Hosea 4, verse 6. I have completed the Chief Justice knew it all by heart. My people are destroyed for lack of knowledge. Buddha, on the other hand, recognizes that you have much learning to be skillful in handicraft, well trained in discipline, and to be of good speech. This is the great blessing. And finally, the Holy Quran also teaches us in Surah Al-Zumar 39:9. Are those equal? Those who know, or those who do not know? It is those who are endowed with education, understanding, that receive admonition. Now, despite this obvious ancient virtues, access to teaching and learning has not been freely and widely accessible to all people at all times. All forms of human oppression and exclusion are premised to varying degrees on a denial of access to education and training. And even power relations that mark slavery, colonialism, industrial age, and the information economy are girded in great part by inadequate access to quality teaching and learning. At the end of the long and glorious struggle against all forms of oppression at the beginning of our democratic and inclusive society, we, filled with a rightful optimism, guaranteed universal access to basic education. We collectively said everyone has the right to basic education, including adult education. Even so, disputes and access to basic education in our society are not scarce. There are continuing contests for the governance of public schools and policies on admission of learners. This despite a number of precedents of our courts that were meant to clear the murky waters of the shared space between school governing bodies and provincial executives charged with the regulation of public schools. Here, in this case, this contestation plays itself out in the validity of amendment of regulations of admission of learners to public schools in Gauteng. On the 18th of July 2011, member of Executive Council for Education, Gauteng, the MSc, published draft amendments to the regulations and invited comments from the public. The Federation of Governing Bodies of South African Schools, FEDSAS, submitted that a number of regulations be withdrawn as they were ultra vires. The MUC's powers flouted the principle of legality or caused a conflict between national and provincial legislation. The amendments were promulgated on the 9th of May 2012. In the High Court, FEDSAS challenged the validity of the amended regulations, and after considering each of the impugned regulations individually, the court held that several of the regulations were indeed inconsistent with the Constitution. The High Court saved only one of these regulations, in Regulation 5.5. The MEC and the head of the Department of Education in Gauteng were unhappy. They petitioned the Supreme Court of Appeal. The court upheld the appeal, save for Regulation 22A, which was struck down. In this court, FEDSAS submitted that some of the impugned regulations were neither reasonable nor justifiable in terms of Section 4 of the Gauteng School Education Act, 1995. It further contended that there was a conflict between some regulations, which is provincial legislation, the South African Schools Act, which is national legislation. FETSAS argued that this conflict rendered the regulations inoperative by virtue of Section 149 of the Constitution. It submitted that the MEC's reasons for introducing the impugn regulations were without a proper factual basis. The MEC and the HOD contended that the public schools cannot be governed in a manner that only catered for the interest of its incumbent parents and learners. They submitted that the regulations were rational and reasonable. They argued for the validity of the impugned regulations in the light of their purposes. Equal education was admitted as a friend of the court. Its main submissions highlighted the inextricable link between geography and race in our land, and drew the court's attention to the inadequacy of proximity as a sole criterion in the determination of feeder zones in the interim in nature had the effect of unfairly discriminating between entry-level learners, in effect based on race. In a unanimous judgment written by me, and therefore in which Mogoeng CJ, Cyril AJ, Cameron J, Jafta J, Fonneman J, Khandebe J, Madama J, Tantra J, Nkabila J, and Zonda J concurred. We hold that there is no conflict between provincial and national legislation. This is because education is a functional area of concurrent national and provincial legislative competence. The Constitution anticipates the possibility of overlap and conflict between these legislative competences. We hold that the regulations can be read in harmony with the national legislation, and that none of the impugned regulations are unreasonable, unjustifiable, or irrational. A little detail. Regulation 3.7 disallows a learner's prospective school from requesting confidential information from her current school before the admission of the learner into the new school. Its legitimate thrust is properly aligned to the objectives of preventing unfair exclusion of a learner at the point of admission to a school. For this reason, we hold that the regulation is rational. Regulation 4.1 and 4.2 empowers the MEC to determine feeder zones. We find that the default feeder zones regime provided for in Regulation 4.2 was intended to be transitional. This is because these feeder zones are set unilaterally and might deny relevant stakeholders meaningful participation in a matter that affects a school materially. Regulation 5, read with Regulation 8, empowers the district director to place an unplaced learner at a school that has not been declared full by an HOD. This court holds that the regulations are rational, are reasonable, and justifiable, and are not at odds with Section 5.5 of the Schools Act. The HOD's power to determine learner enrollment capacity and to declare whether a school is full or not assists the MEC to ensure that there are enough school places for every child, and every such child is placed in a school to learn. Regulation 11.5 and past the district director to consider the relative capacity of other schools in a district as a criterion for placing a learner in a particular school. We hold this regulation to be reasonable, rational, and justifiable, as its guiding purpose is to ensure that every learner is placed in a school, a duty imposed by our Constitution. Regulation 16 allows a parent to lodge an objection with the HOD before appealing to the MEC. This court holds that the regulation does not add an extra layer to the appeal process and that it does not, in fact, amount to delegation of powers. All these reasons, we unanimously make the following order. 1. Leave to appeal is granted, save in respect of the abandoned costs order of the Supreme Court of Appeal. 2. The appeal against the order of the Supreme Court of Appeal is dismissed, subject to paragraph 3. 3. The first respondent, member of the Executive Council for Education, Gauteng, is directed to determine feeder zones for public schools in Gauteng province in the manner required by Regulation 4.1 of the regulations relating to admission of learners to public schools within a reasonable time, but not later than 12 months from the date of this judgment. I hand down the judgment.
That marks the end of the formal session of this sitting. We will then move to the second leg of this special sitting, which is to bid farewell to the Deputy Chief Justice and pay tribute to him. Let me begin in this fashion. Maruna Moseneke, again we thank you because we can't thank you enough for having ensured that South Africa gets to be privileged to have this lawyer of exceptional abilities and a legal giant without doubt, a jurist whose contribution to the development of our constitutional jurisprudence defies description because you risk understating the enormous contribution he has made to the enrichment of our jurisprudence. The man who was intimately involved in drafting the Constitution that is celebrated all over the world. We just can't thank you enough. We thank you also because he kept on telling us that when the going got tough, you would say to him, son, let's kneel down and remember the Almighty God. Maybe that is why he regards me as his resident pastor. I also just want to acknowledge his dear wife, Moseneke, for her role, selflessness, her support, and the entire Moseneke family. Your Excellency, President Mbeki, we appreciate the time you took off your busy schedule. We know that presidents like judges never really get to retire. There's always so much more to do. President Motlanthe and our mother, Mema Motlanthe, we're very grateful. And before I forget, my dear wife, Mampefo, particularly because it's your first time inside of this building, I appreciate your support. The Honorable Chairperson of the National Council of Provinces, Mekhandi Mudise, we treasure your presence. The Deputy Minister on behalf of the Executive, Deputy Minister Jeffrey, thank you ever so much. I thank you even for things I can't articulate publicly, but which I mentioned to you yesterday. The President of the Supreme Court of Appeal, Justice Laxmi Party, the Deputy President of the Supreme Court of Appeal, Mandisa Maya, Transformation Agent, the Justices of the Constitutional Court, 7, retired, the Justices of the Supreme Court of Appeal, Judges President and Judges Present, distinguished South Africans, good morning. It's very difficult to know what to say about a man as distinguished as the Deputy Chief Justice. I think in a gathering of this nature, it should be more about what is it that his life communicates or has communicated over the years to us. What message is to be drawn, what lessons are to be drawn from a life so well lived, from this kind of a role model. And let me touch on this because he was able to touch on it last week. One of the profound lessons to draw from his life, from his endurance, is this. He's living, and every normal human being who is a justice of the Constitutional Court would want to step into his shoes and become the next Deputy Chief Justice. But what if it doesn't become you? Must the institution, the Constitutional Court as an institution, or the Judiciary as an institution be destabilized because you did not get what you believe you and you alone ought to get? Don't betray the lesson that this great leader has blessed us with. He didn't throw tantrums when he was unquestionably, eminently qualified to take over as Chief Justice of the Republic. He knew that he was deserving, he knew that he was qualified, he knew that all things being equal as the Deputy Chief Justice, it was proper, it was appropriate to hope, to believe that you would naturally become the Chief Justice. But I love what he said, is that, you know, it's an honor just to be a judge, even a judge of the High Court. It's more of an honor to be a justice of the highest court in the land. And it's even more so to be the Deputy Chief Justice of the Republic. And also there is a presidential prerogative as to who becomes either Deputy Chief Justice or Chief Justice. My responsibility is more to the nation than to myself. That's a lesson to draw from the experience, and I dare say, the unimaginably painful experience that the Deputy Chief Justice of the Republic has had to go through, has had to endure. So my colleagues, it's normal to aspire. It is permissible to aspire, but don't betray the legacy of this great time. Let there be no tensions in this court and the broader judiciary just because it didn't become you. Like him, embrace the new leader, whoever she or he will be, and let the business of the nation be carried forward so that the judiciary can continue to be that arm of the state. The broader public has confidence in to do what needs to be done at any given time, whether it's preferred by the majority or the minority. Just remain loyal to its affirmation or oath of office. South Africa has many challenges, does it not? But the hard work behind the scenes of leaders like the Deputy Chief Justice of this country, the hard work by some of the leaders here present, President Mbeki, President Moseneke, has helped us appreciate when it looked absolutely impossible the depth of the capacities and the collective wisdom, the unimaginable resolve of South Africans that had never been tapped into before the early 1990s. All these problems that we have, and there are many, can be solved. If in the midst of intense hatred, and I say hatred advisedly, and tensions between black and white South Africans, exacerbated by the death of Chris Hani just at the wrong time, could not derail the mission to accomplish freedom in this country, then there is no problem beyond South Africans when they commit to finding a solution to it. The truth of the matter is, when Chris Hani died, I believe almost all South Africans were sure that the negotiations were doomed. But here we are. We have a black Chief Justice, a black Deputy Chief Justice. Look at how many black judges are here. The fruit of the determination by white and black South Africans to do what is in the best interest of their country. So, very much in line with the preamble to our Constitution, let's join our hands together, if only to remember the sacrifice of this man at the tender age of 14. I think that's history. Your championship in that regard remains unsurpassed. Unlike many of us, he doesn't know what it means to play marbles and to play soccer with no real goalpost, I suspect. If he does know a bit about it, he has seen others participate in it. Just so that South Africa doesn't fail. It becomes a shining example, not only to the continent, but to the global village. It would be a betrayal of that sacrifice and the suffering that Moseneke and the entire family had to endure as a result, just so that we make the most of the possibilities that are all over us as South Africans. So, live in this room. Let's go out there and make our own contributions based on what he has already done in mending race relations and address the racial tensions in this country very calmly, maturely, and with the wisdom that we have. It's never going to help to go blow by blow. It requires a sober reflection in line with the preamble to our Constitution that says the divisions of the past, which were founded on racial discrimination, must be healed. That's what this man has been fighting for all his life up until now. That is why Edwin Cameron is the one who paid tribute to him. Not because he was trying to be progressive, but because he is. We must speak out as South Africans against destruction. I mean, our schools get burned, national assets get burned, but you hardly ever see South Africans get angry that their national assets are being destroyed. I mean, in memory of this man, we owe it to ourselves, we owe it to posterity, that our voices begin to be heard and say, enough is enough. Let's not just report the damage without collectively and loudly condemning this wrongdoing. Let us never appear to be sympathetic or understanding to destruction. He could have been bitter when he came out of Robben Island. He wasn't. He could have refused even to go anywhere near the Pretoria bar. They even did not want to admit him. But because he was not bitter, it is to the Pretoria bar that he turned to sharpen his forensic skills. As judges, we are enjoined by the Constitution and our oath of office to be independent. We should never seek to be affirmed by anybody. And I must make this point. I know that some people get angry when I cast it as broadly as I'm going to. It is not just independence from the executive or parliament. No. It is independence from even opposition parties. It is independence from big business. It is independence from the media and all the many aspirant kingmakers out there who seem to think that without their support you can't make it in life. He has defied the odds. We have the only way in which we can give practical expression to our constitutional mandate as the judiciary is not to pretend to be true to our oath of office, but to be true indeed. A judge should never find himself or herself in a position where some people are always guaranteed success before the case is even heard. It should never be that way. That is the worst form of corruption in a constitutional democracy. It is that time in the history of South Africa where we've got to pick up something from some American people. I think it was actually a borrowed expression that J.F. Kennedy used, borrowed from, I think it was George Washington, if not Churchill. Ask not what your country can do for you, but rather what you can do for your country. That is the spirit At the time of his disappointment, he had asked himself, what is it that I can do for my people, for my country? Let us be selfless. Let us be content with the little that we have. And remember always that there are multitudes out there who go to bed on an empty stomach. Let's internalize these wisdom-laden words and give practical expression to them. I think I've spoken for rather too long. Let me call the next one. I call upon Advocate Mr. Zabeza, SC, to speak on behalf of Advocates for Transformation. We call him Brady. Even if I'm wearing a gown, I'll call him Brady because it's not a formal session. Brady, please, time.
Hey, Chief Justice has been taking so much time.
Those are the benefits of being Chief Justice.
This is an occasion like no other, and I've been in a few occasions of this nature in this court. I've never been in a similar occasion where people were allowed to clap. It just makes this one occasion the unique occasion that it is. Chief Justice, you have assisted me in identifying the luminaries today, from presidents and Mbeki and Motlanthe to the heads of courts, and indeed to the honorable justices of this court, past and present, and to the leaders of the other courts and members of those courts. So I will not go step by step in recognizing those. They are recognized. I will, however, recognize our most esteemed honored guest, his dear wife, his family, his extended family, who may be here. Honorable South Africans, comrades and friends, I'm very privileged to speak on an occasion marking the retirement from this bench of the Deputy Chief Justice of the Republic of South Africa, Comrade Ernest Dikgang. I cherish the privilege more when I look back at what I believe everyone will agree has been a life lived in full. A checkered history of struggle, trials and tribulations, cross-cutting a number of occupations in his career. A life which we will never be able to speak sufficiently well of on any respect thereof, let alone in 10 minutes. It is a multifaceted life history, from a political rebel to a professional lawyer, from a political jailbird to a prominent judge of this court. And today we have come to know of his keen interest in Christianity and Islam. It is hard to imagine how all of these terms can be used to describe, in a broad brush against canvas fashion, the career of one individual, except when that individual is Ernest Dikgang Moseneke. Chief Justice, your deputy has had battles with abandonment, and we cannot cover all of them. He had battles with apartheid South Africa even after his release from Robben Island. from the time that the law societies objected to his application to be admitted as an attorney on the basis that he was not a citizen of South Africa, but a citizen of an independent state called Botswana. He had trials and tribulations when his application to become an advocate of the Pretoria Bar raised controversy within the Pretoria Bar because of that, up to that point, that bar had been an exclusively white bar or had an exclusively white membership. We will remember, Chief Justice, the delicate balance that your deputy struck in articulating here and abroad the radical stance of the Pan-Africanist Congress of Azania's slogans on a number of occasions, and balancing that with his practice as an advocate of the High Court of South Africa. There was one slogan which he had to contend with here and abroad: one settler, one bullet. It was always going to be problematic, and it was. I am sure all of us immediately recall how on national television Comrade Moseneke was put under the spotlight by Mr. Adrien Steed, an ANC anchor, about exactly that slogan. Time and space do not permit me to give a blow-by-blow account of that interview, except to say that he gave as much as he got, and judging by a nationwide reaction from most black people, he won the debate hands down. His political engagements, especially as the deputy president of the PAC, were held by many to be the reason that his chambers became the object of a bombing attack that might easily have been aimed at him. We are happy that he survived. So many people, Chief Justice, will be more qualified than I am to talk about his milestone as an intellectual thought leader in the development of our constitutional jurisprudence. Their judgment, I am sure, that he must look back at with a level of satisfaction, because they shaped our jurisprudence and contributed to accolades from juriscommentators and specialists like Professor DeForce, who spoke glowingly of him about his commitment to fairness and justice. A number of journalists, notably one Niren Tosi, have ascribed him as the most independent-minded and imaginative jurist. This was one of the accolades that came his way when he penned the majority judgment with Cameron J. in Glenister, where they found that the legislation did not sufficiently insulate the members of the police from political interference. There are some judgments which the Deputy Chief Justice will look back on and must wonder if he would have written in the same way where he confronted with those issues today. You will know that the Masetla versus the President of the Republic, who is here today, which effectively held that the National Intelligence Agency head, Billy Masetla, was not entitled to procedural fairness when he was dismissed by President Beki is one such judgment. You are also known to have penned a piece in which you highlighted the enormous power that the Constitution has given to the President of the Republic. Cynics have reacted to that piece by saying, you should have been aware of this when you were one of the drafters of the Constitution. Those who are kind to you say, cynically too, I believe, that you did not lament the enormous powers that the Constitution gave to the President of the Republic because you thought that all the presidents would be like Mandela. What it is that inspired that piece, time will tell. There are, however, two judgments on affirmative action that you have become the leading cases in that area. And those are the Minister of Finance versus Van Heerden and SAPS versus Solidarity on behalf of Barnard. I am precluded from making further comments on affirmative action because of a judgment on the subject in which the same subject was under consideration in this court, the case of Solidarity versus the Department of Correctional Services is still outstanding. Having been a member of the legal teams involved in that case, I will wait to see your contribution to the affirmative action some students traversed in that case repeatedly. As you retire and as you write your memoirs, you are going to be challenged, now in retirement more than in your time on the bench, to make unequivocal pronouncements on the question of expropriation as a tool for redress in land reform. There are angry voices out there that I'm aware have been calling for more radical judgments on land restitutions. They have been following your speeches in and out of court. Quite apart from the EFF, I'll mention that one of them is a former member of the EFF, one Andile Mutama, now of a movement called Blackfest, Landfest. On your retirement, I invite you to read his critique of one of your extraterritorial speeches on the subject of expropriation in what he calls black opinion. He asks inter alia the question, before we begin to talk of compensation, never mind the question of whether compensation should be just and equitable, the first question to ask is, whose land are we talking about? I can only imagine that Mutama postulated this question because he knows that you, as a political animal who suffered for the Pan-Africanist Congress of Tanzania and who has recently described Jafta Masimula, the tiger of Tanzania, grew up in an organization where the rallying cry, amongst others, was, is belief. That remains your unfinished business. And in that unfinished business, you will encounter a lot of vibrant and robust debate. Lest we forget, Chief Justice.
On behalf of the Black Lawyers Association.
Thank you, Chief Justice. Like Radi has indicated, protocol has been observed. I'm deeply humbled and honored to stand here today and bid farewell to this appropriate words to start to describe the role the Deputy Chief Justice has played in transformation of our country. Deputy Chief Justice, since you were born, it was written all over you that you are destined to dispense justice. In search of justice, freedom and equality, at the tender age of 14, you joined active politics when it was not fashionable to do so. It was an offense which could attract capital punishment. Nonetheless, Chief Justice, nothing stopped you from doing what you believed was right. For your quest of justice, at the age of 15, you were sentenced for an effective term of 10 years imprisonment. That did not overwhelm you. To you, rather, it was another opportunity to prepare yourself for the future through education. You attended your university through correspondence in order to achieve what you have become today. You are a freedom fighter. As a practitioner, in opposing oppression of the time you assisted in the formation of the Black Rights Association, you opposed the undemocratic nature of the law societies. Your efforts helped in the formation of the Law Society of South Africa. Compromised as it is, Black practitioners found voice in it as opposed to its forerunner, the Association of Lawyers of Law Societies. You played your part in the transformation of the legal profession. Bradley has indicated the fights you waged against the Law Society for your admission and also against the bar to be admitted in that exclusively white bar. Chief Justice, we are gathered here today to celebrate the life and achievement of this great son of the soil, the humble servant of the people of South Africa. DCJ is a judge whose judgments have always been hardly thought. His judgments are not influenced by emotions, prejudice, or stereotypes. In his judgments, there is no favoritism or fear. Chief Justice, the departure of Deputy Chief Justice Moseneke will leave a void in your court, which will never be easy to fill. I hope the President will find someone to replace him and fit squarely in his shoes. But there is nothing that we can do about it. This was bound to happen because he has to retire. What is, however, pleasing, DCJ, is that you are not leaving us forever. You will always be available when South Africa needs you. BLA will, of course, have time to come and tap knowledge and wisdom from you. Today, you are only retiring from active service as a judge. DCJ, the country looks at you as one of the strongest judges in the country, a towering legal mind, and for your commitment to fairness and justice. All your judgments are to me a must read. I will not pinpoint one, Bradley has done that, and eloquently so. With your sharp mind, please engage in the national discourse and make your voice be heard. You will be most suited to tell judges that a racist judge has no room in the South African judiciary. We know we shall hear your voice and your truly reasoned advice to those who, out of frustrations, ban national infrastructure like schools and libraries. You will tell them that you did your schooling through correspondence when it was not easy when you were in prison. And you will tell them to cherish what they have. You have played your part. You deserve a tranquil retirement. Like Robert Mangaliso Sobukwe once said, here is a tree rooted in African soil, nourished with waters from the rivers of Africa. Come and sit under its shade and become with us the leaves of the same branch and the branches of the same tree. Find a good African tree and take a good rest. We love your writings. Put pen to paper, we shall read. Thank you, Chief Justice.
Thank you very much, Mr. Sigoma. On behalf of the National Association of Democratic Lawyers, NADEL, and the Law Society of South Africa, I call Mr. Moseneke.
Thank you, Chief Justice. As previously indicated, I was saying all protocol observed. It is a singular honor and privilege for me to stand here and share with you the experiences of both NADEL and the Law Society of South Africa with the Honorable Deputy Chief Justice. As my colleagues in the two organizations were reflecting on separate occasions on their experiences with the Honorable Deputy Chief Justice, I was reminded of my own personal experience and interaction with the Deputy Chief Justice. These experiences and encounters are best described by an Eastern Cape old man who talked to his children about the sunrise and changing weather. This old man, expressing himself in Xhosa, described the situation as follows. Uvakala izithonga zendudumo umenyeza imibane kwangentathakusa suke sefuku isithotho kusabukelwe ngamayeyeye kugxothwa isithotho sifudiselwa embo kuba khona kusithiwa kudliwa ngendebe endala cimana nomathotholo nezihlobisi hleze zinibize imibane suke kweruhambo ubumnyama asazi nalapho singatshona khona inkwenkwezi eyodwa ekhanyise ngathi lilanga ixela leyo iphuma empuma ikhombisa izazi apho usana khona. So Deputy Chief Justice, early in your childhood upbringing, life presented you with an option to choose between action or inaction. In either choice, there was no easy walk, for the consequences were most severe. In the midst of this call, guided by your conscience, you decided to walk along the road of heroes and heroines. In the words of former President Thabo Mbeki, I quote this. You have borne the pain of those who have known fear and learned to conquer it. You have marched in front when comfort was in the midst of the ranks. You have laughed to contend against a river of tears. Perhaps, amid temptations, you refused to succumb to the worshipping of the beast, for you knew that whoever worships the beast and its image and receive the mark on their forehead or on their hand will themselves drink the wine of his fury, which he has poured at full strength into the cup of his anger. At the tender age of 14, you must have been a courageous man to choose the side of the oppressed and champion their cause. It must have taken a special wisdom at one's risk, since the wrath of the oppressors were subject to no restraint awaited. The pain and suffering of your people, coupled with the vision of a free society in which all would enjoy the universal freedoms, compel you to reject and abandon the life which the majority of your age group elected to live. Prospects of solitary confinement, long imprisonment, torture, and long separations from your parents became a path to endure for a cause of the majority and the future of your people. A selfless sacrifice such as this formed the basis of the struggle of our freedom. The sacrifice you made at a time when few could do did not make you more important than the others. Equally, it did not translate to you being more intelligent and superior to the masses of our people. Indeed, yours was to be a participant in a process that would culminate in a caring society where all live in equality and have access to justice for all. This sacrifice was made by you regardless of impending deaths, including that of family members. Instead, all these sacrifices were made with no prospects of imminent and prospective personal gain. No price tag was set for the sacrifice you elected to make, but the much awaited reward in your mind was the freedom and prosperity of your people in society, where they would live as equal people enjoying their freedom, which include equality and equality of opportunities. For these prospects, you resolve to join your suffering people in the destruction of apartheid and its system. Indeed, you are a courageous man. You crown it all by participating in the drafting of a document that envisages the new South Africa, which you initially imagined as a young person. Our constitution set in motion South Africa in which all enjoy freedom and equality, subjecting those in power to act with accountability in a more transparent and checked manner. Your response to the call by masses to assume the responsibility of the bench was an attestation to the commitment you made for the freedom of your people. As I understand it, your personal importance or position were never a consideration. Guided by your conscience, you easily agreed to leave your lucrative practice and other responsibilities which brought personal wealth and riches. Your commitment to our people and the life of South Africa, as promised in the Constitution, is fortified in your numerous written judgment. Brady has already referred to the case of Leinster versus the President of the Republic of South Africa. Most importantly, I will refer to the case of Walindile Community versus King Sabata Talengia Municipality, where you stated the following: I must, however, dispel the suggestion that a right to claim restoration of rights in land under the Restitution Act is not an existing right. One such right would certainly be the right warranted by the Constitution to lodge a claim for restoration of the land in question. This case is very important in view of the outcry by many of our people for the return of their land and proper distribution under the constitutional democracy. This case took into account the undisputed evidence of the fact that community had lived on the land in question for nearly 2 centuries, something borne out by the ancestral graves located in the vicinity of the land claimed, which ancestral graveyard the municipality had in its ordinary meeting acknowledged. Deputy Chief Justice, you leave us here not because you have to stop. You leave us here because you have to start again. The Law Society of South Africa asked a rhetorical question: why must it be now? Our country calls for a leadership that is not corruptible. Our country needs a judiciary that is independent to safeguard our constitutional democracy. Our country needs direction in the midst of confusion and threatening chaos. However, Natal insists that the new station will be its offices. And you will start where you left off. Our people still cry for freedom and equality. The majority of our people are yet to taste the much promised freedom in our constitution. The culture of human rights is yet to be realized and enjoyed. Your coming back to Natal is more welcome and highly appreciated. There is no retirement, but rather the beginning of all beginnings. You must start again. Keep on keeping on. Thank you.
Thank you very much, Commissioner Notice. He's a commissioner of the JSC. Next is Mr. Jeremy Miller, SC, on behalf of the General Council of the Bar.
Thank you, Chief Justice, other justices, retired judges, honored guests, and Deputy Chief Justice Moseneke. Reactions to the retirement of prominent individuals come in a variety of forms. Many retirements are greeted with universal relief, some with indifference, a few with mixed emotions, and the very few, with reluctance to acknowledge that the end of an era has arrived, and with sadness even. And today we mark the retirement from this court of your tenure, and I know of someone whose absence will universally evoke the last mentioned feelings. At least they will from lawyers across the country, from some sectors of our body politic, perhaps not quite so much. Deputy Chief Justice, like many who have transcended excellence and intruded into greatness, your career has chalked up what appear to be several lives already. Aspects have been touched on already, and if one just simply runs through a few of the chief milestones, you used your 10 years of incarceration on Robben Island to acquire 3 law degrees from your alma mater, the University of South Africa. You then joined a firm of attorneys in Pretoria, practiced briefly as an attorney before you were called to the bar in 1983. That had the effect of abolishing the whites-only rule at the Pretoria bar. 10 years later, you were part of the committee which drew up the interim constitution. In 1994, as deputy chair of the Independent Electoral Commission, you helped supervise the first of our democratic elections. In 1995, after 12 distinguished years at the bar, you entered the corporate world and for the next 6 years rubbed shoulders with what my daughter sometimes refers to as the suits. Before you returned to your first love, law, in 2001. And after a brief tenure as a High Court judge, you became a justice of this court. And in 2005, Deputy Chief Justice. You graced that position on this court for more than 10 years. Your contribution to the work of the court has been immense, but it's invidious to try and single out particular judgments on an occasion like this. What is evident, however, is something that R.D. touched on, and that is your particular interest in land issues and land rights. In a recent paper, you referred with approval to the following observations of Frans Fanon in his work entitled, in the English translation at least, The Wretched of the Earth. This was the quotation that caught my eye. For a colonized people, the most essential value, because it is the most concrete, is first and foremost the land. The land will bring them bread and, above all, dignity. Fanon was a Frenchman, and like some of those in our country who affect the wearing of jaunty French berets, Radi, Justice Moseneke's view, at least for the time being, subject to what lessons we've taught him this morning, is that the glacial pace of our land reform program is not the fault of the Constitution. The fault lies elsewhere, bureaucratic sclerosis and other impediments. And you've pointed out that the property clause in our Constitution does not contain that notorious phrase of which we read so much, namely, willing buyer, willing seller. And that the market value provisions in the Constitution list market value as only one of the criteria which the court must take into account when setting fair compensation for land expropriated. You've authored a number of important judgments in the field of expropriation and the constitutional right to property, including the Iran Property Development versus City Cape Town decision, Shoprite Checkers versus MEC for Economic Development in the Eastern Cape. And these and the other cases give concrete expression to your view that social justice and cohesion will remain unrealized ideals for as long as urban and rural land injustice dominates the lives of the majority of our citizens. Despite your stellar career, Justice, Deputy Justice, you have experienced one, perhaps two disappointments. Those setbacks were referred to by the Chief Justice. They may have called to mind the wry observation by Oscar Wilde, who said that to lose one parent may be regarded as misfortune. To lose both looks like carelessness. If it was due to carelessness that you suffered those disappointments, it was carelessness of an admirable kind, and in all likelihood your determination to speak publicly about the things that animate you. not too long ago, you delivered a paper at a conference. You started by publicly reminding yourself that although a product of our revolution for a just society, you were a sitting judge and that you were accordingly going to speak like a judge, or as you put it, you were going to stick to your knitting. Reading the speech recently, I regret to say that I don't know that you did stick to your knitting, at least not entirely. And the paper, may I say so, was all the better for it. An inclination to outspokenness outside the confines of this court has doubtless provoked the ire of prominent persons. Who knows, perhaps it may even have contributed to one or two of your disappointments. But it has made a significant contribution to the public discourse on the role of judges and the primacy of the law, and in particular the primacy of the Constitution, in a way which a judgment may not always be able to do. Mind you, those who have shown a sensitivity to some of your remarks extracurricularly may be grateful for the fact that they are not counsel appearing before you on those rare occasions when you felt it necessary to say something about a submission which you considered inappropriate or absurd. Many would have witnessed your polite but pointed reprimand of counsel for Parliament during argument in the Public Protector case recently, when her manner exceeded the bounds of acceptable enthusiasm to the point less than a week ago, if press reports are to be believed, one of our leading silks, who is here today, was somewhat brought to heel. According to those reports, Justice Moseneke, who posed to him the same rhetorical question in the IEC case as the well-known tennis prodigy of a few years ago, John McEnroe, used to pose to startled chair umpires something like, "You can't be serious." And again, if press reports are to be believed, counsel for the IEC gave the question serious consideration for a millisecond before indicating that, on reflection, he had no further submissions. Perhaps your occasionally stern demeanour is something learned from the days when you served on the disciplinary committee of the Makana Football Association, which I understand was the prisoners' self-governing football body in Northern Ireland. There is, of course, the other side to you, the side which so struck a young female advocate at the Pretoria Bar that she wrote about it in an article some 10 years ago. Mark your elevation as Deputy Chief Justice, and for her great admiration for you. We'd started together at the Pretoria Bar, and she wrote of that shared experience. One black man at the Pretoria Bar, the first, and she, a female. Neither entirely welcome at the bar at the time. And of the camaraderie of those times, she wrote, "The greatest dreamers of all was Advocate Moseneke. And today, as Deputy Chief Justice of the Constitutional Court, Justice Moseneke has lost none of his youthful energy and enthusiasm. His effortless and meteoric rise to fame has left him as humble and unassuming as when I first met him." Later in the article, she described you as a genial friend of life's banquet, and finally called in aid that old Yiddish expression describing you as a mensch. And if you recall the article, Deputy Chief Justice, you will recognize the particular poignance and the irony perhaps of those words coming from that author. One other anecdote perhaps will serve the case. Writing some time ago of the effect which the then advocate Moseneke had on his life, another author recounted an incident from 1986. That author had just completed a rather unhappy stint doing fact work at a conservative law firm in Pretoria. He was introduced to then advocate Moseneke, who asked him about his future plans. And still unsettled by his unhappy apprenticeship, the author replied that he was thinking of journalism because clearly he was not cut out to be a lawyer. Advocate Moseneke disagreed and told him the country needed good human rights lawyers, and that doing something worthwhile with his law degree would benefit the people of South Africa. And today, thanks to that conversation, the author is a professor of law and runs what is probably the best known blog in the country on constitutional and related issues. So in conclusion, Deputy Chief Justice, both as a jurist and as a person, you've touched lives, you have changed lives, and you've had a part indeed in shaping our society. And our society is the better for it. As you contemplate some well-deserved R&R, although listening to some of the speakers this morning, perhaps I'm not so sure about that now, and also your imminent travels to this continent, there can be no greater accolade than for you to acknowledge this accomplishment. So, Deputy Chief Justice, on behalf of the General Counsel of the Bar, we thank you for your immense contribution to the law and to the country, and we wish you and your family everything of the best for the future.
Thank you, Mr. Miller. Next is the Director of Public Prosecutions, hoping on behalf of the National Prosecuting Authority, Mr. Johannesburg.
Thank you, Chief Justice. I stand here as one representing one component of the criminal justice system, which is the courts with itself. But, Honorable Justice, Justices of the Constitutional Court, Deputy Minister of Justice, Mr. Jeffries, Chairperson of the Council of the National Provinces, Moseneke, President Dikgang, President Moseneke family, all honorable judges present here, distinguished guests, and all people of South Africa. Allow me on behalf of the National Prosecuting Authority to express our sincere gratitude to have been invited to share with you the farewell of one of the greatest legal minds South Africa has ever seen. We in the NPA were privileged to have worked with Honorable Chief Justice Moseneke, both when he was practicing as counsel and when he was the judge, as well as justice of his court. We have experienced this sharp legal critics of our processes as well as our presentation of cases before him, both in criminal courts as well as appeal courts. We are better placed today and into the future to conduct prosecution of matters without fear, favor, or prejudice, all because of his guidance and counsel. We have many experiences and memories that we can share with you regarding Honorable Justice Moseneke. We wish to thank Honorable Justice Moseneke for his service to South Africa and to humankind. The NPA would not have succeeded in its endeavor were it not the guidance and assistance that Honorable Moseneke has given to us. Lastly, we wish to congratulate Deputy Chief Justice Moseneke. We wish him well in his retirement and hopefully other engagements within society and community at large. And sincerely hope you will remain a watchdog to the conduct and behavior of the NPA. Thank you.
On behalf of the executive of this country, I call upon the Deputy Minister of Justice and Constitutional Development, Mr. John Jeffrey, MP.
Thank you very much, Chief Justice, Deputy Chief Justice, other Justices of the Constitutional Court and other judges present, former Presidents, Mbeki and Moseneke, all other distinguished guests. I'm standing in for the Minister of Justice, who's unfortunately out of the country. In a speech in May last year, Deputy Chief Justice Moseneke speaks about how in traditional African culture, the shade of a tree was the place where disputes of society were mediated and resolved. The community would meet for a lahutla, and there was room for all to have their say. Everyone participated in the process. This was how justice was done. It is what the Deputy Chief Justice calls the age-old concept of justice under a tree. He continues to say that the court we're in today is a gentle reminder of this. The overarching theme of the Constitutional Court building is justice under a tree, and as former Justice Sachs described it, the tree protects the people and the people look after the tree. There is a striking symbol of the synergy between justice and the people. Deputy Chief Justice Moseneke has dedicated a lifetime in protecting that tree. From the tender age of 13, he fought for what was right. In 1960, Dikgang Moseneke saw what had happened in Sharpeville, and he later recalled, and I quote, "The inequality was egregious. You could see it out there, jumping at you as a young person. My sense of fairness was inbred, and I think it's inbred in every child. And just remember the sense of right and wrong of young people. My grandchildren now tell me, 'Grandpa, why does he get 2 sweets and I only get 1? It's unfair, Grandpa.' The kids are the first to say it." That's the end of the quote. As a result of seeing the Sharpeville massacre, he decided to join the African Student Union. 3 years later, he was taken from his home by the police. For 90 days, he was tortured and held in solitary confinement. In many of the interviews and articles written about the Deputy Chief Justice, there is one person who stands out, his mother, Mrs. Karabo Moseneke. In a speech delivered in 2011, the Deputy Chief Justice says, and I quote, "Those who know me will tell you that my hero of all times is my mother." Mrs. Moseneke tells of how when he was detained in 1963, his family had no idea where he was being taken, and how they searched and searched. When Mrs. Moseneke eventually found out where he was about to stand trial. Every day the police would ask Mrs. Moseneke the same question, if she was number 6's mother, and every day she would give the same reply, "Tell them that I am the mother, I am definitely the mother." Then the guards would tell her that her son, number 6, was sure to hang. At his trial, his parents begged the judge not to send their son to jail, but Dikgang Moseneke was sentenced to 10 years in jail for conspiracy and sabotage. He became the youngest prisoner ever to be taken to Robben Island. Much has been said about the Deputy Chief Justice's academic achievements, in particular how he completed his matric, a BA in English and Political Science, and to be juris whilst on the island, and later his LLB. We also know of his involvement in the now famous Makana Football Association while on the island. But what struck me most is how Mrs. Moseneke, being a school teacher, would only visit her son on the island during school holidays, and how she would drive all the way from Gauteng to Cape Town just to be able to see her son for only 30 minutes. She was so shocked by how hungry and emaciated he was. She tells of how she persuaded a warder to give her son a foil-wrapped roast chicken, which he devoured. She says, bones and all. His story is one of inspiration. The teenage political prisoner from Robben Island, by virtue of his razor-sharp intellect and his dedication to justice, became a candidate attorney, who became an attorney, who became an advocate, then a silk, then a High Court judge in 2001, a Constitutional Court judge in 2002, and he has served this country and its people as our Deputy Chief Justice since 2005. His achievements, accolades, awards and professional appointments are formidable. City Press in 2012 in an article about the Constitutional Court writes the court consists of a progressive bench, including, and I quote, constitutional rock stars like Chief Justice Dikgang Moseneke. Speaking from the side of the executive, our courts have over the past 2 decades held government accountable to ensure in particular that socio-economic rights of the poor and vulnerable. Whether it be healthcare, housing, social grants, or the eviction of homeless people, our courts under the able leadership of judges like the Deputy Chief Justice have not shied away from compelling government to do what the Constitution requires. We know him as a highly principled, fearless and outspoken jurist, one who never shies away from speaking his mind, one who pronounces on the law without fear, favour or prejudice, a man who's not afraid to speak truth to power. And I would argue that this is what makes him a constitutional rock star. It's his humanity. It's his ability to comprehend the human condition, to see human beings as human beings and not mere parties to litigation. And this makes Dikgang Moseneke one of the most respected and astute legal minds in the history of our country. In his interview before the Judicial Services Commission in May 2005, he said in response to a question from Advocate Bezos, and I quote, "You see, talking about bitterness, Mr. Visas, or the lack of it rather, that you talked about, it has been a rather difficult past. It has been a difficult past for all of us. Mine is just one small example, but it has been a difficult past for the whole nation. But once we came to where we are, not just me personally, our constitution is reconciliatory. It is embracing, in fact it is that embracing communal African value of accepting everyone for their worth. There is no time to waste hating others. There is all the time to require of them to help us change and reconstruct this country in a non-racial, non-sexist environment. And that is where my strength personally comes from, and I think that is the strength that informs our Constitution and that informs all of us." End of quote. Ladies and gentlemen, on a lighter note, many things have been said about the Deputy Chief Justice, but one that you maybe didn't know is that in March this year I received a memorandum requesting me to appoint him as an acting additional magistrate for Randburg. It was only for one day, and it was in order for him to solemnize a marriage, but there was an acting additional magistrate. So Deputy Chief Justice, you know you can only play so much golf in one's retirement, so if at any stage in the future you may feel that you miss the courts, we can perhaps always revisit that appointment for Randburg. I learned from the former Minister of Justice, Jeff Hadebe, that the Deputy Chief Justice not only learned mathematics from his father, but also a love of tennis and ballroom dancing. So the producers of Strictly Come Dancing. Deputy Chief Justice Moseneke is also the only judge, as far as I'm aware, who has a rose named after him. And that the rose should carry the Deputy Chief Justice's name is very apt, because the Dikgang Moseneke rose is described as a red garden-cut rose with buds of scarlet red which develop into full blooms. They are long-lasting and each are carried on strong stems. It is vigorous and very prolific. After the pain and thorns of institutionalized apartheid, our constitutional democracy and human rights jurisprudence in particular have blossomed. Just as the rose is carried on strong stems, so too have we great legal minds like Dikgang Moseneke, who have been the strong stems that uphold our constitution. Like this rose has been described as vigorous, so has the Deputy Chief Justice been vigorous in his pursuit of the rule of law, the attainment of human rights, and of justice for all. So Deputy Chief Justice, as we honour you here today, I want to present you with the rose that carries your name. There is a label here which says Dikgang Moseneke. That's the name of the rose. When you plant it in your garden, every time you see it bloom, and apologies, Chief Justice, I haven't replied, but I think it's Rule 26, but condone that. When you plant it in your garden, every time you see it bloom, please know that your legacy and your contribution to our Constitution and our country is invaluable. We wish you all the best in your retirement. May you enjoy the time to spend with your wife, your children, and your grandchildren. We salute you and your enormous contribution to the freedom that we enjoy today. Thank you.
Thank you very much, Deputy Minister. You know, I almost said to the chairperson of the NCOP, is it parliamentary for a member of the executive to present a gift to a member? Thank you very much, Deputy Minister. Next, on behalf of Parliament, is the chairperson of the National Council of Provinces, Meta Dibudise.
Chief Justice, former President Mbeki, former President Moseneke, Justices of the Constitutional Court, members of the Judiciary, distinguished guests, ladies and gentlemen, I confess when I was first told about an invitation to attend, without reading it, I got very agitated. Until my staff looked at me and said, "Ma'am, you are not being summoned to court." And as one of them said, he said, "It is an unjudicial judicial invitation," which led more to my confusion. My fear was, however, not irrational, judges, because you've got to remember how many times the Speaker of the National Assembly and myself have been to court in this last year. So I was very relieved that it was not one of those. I want to thank you, Chief Justice, for the invitation to the Speaker and I to represent Parliament in bidding farewell to the Deputy Chief Justice, Dikgang Moseneke. It is not every day that we get this privilege to bid farewell to a freedom fighter, a fellow ex-political prisoner, a legal practitioner, a former businessman, and a judge. Truly, we are honored to say a few words to a brother, to a father, to a leader, to a citizen who has dedicated his life to serving his people. This is the man who has set foot in the courtroom at the age of 14 as an accused for wanting to set South Africa free. It is that foot that has left the indelible footprint on our court system. I do not know, ladies and gentlemen, how many of the judges today in South Africa or anywhere else in the world who could boast of such a record. An accused and enough as not only a judge, but the Deputy Chief Justice of the country. We salute you, sir, for your contribution to South Africa. You served in the technical committee that gave us a constitution which is still revered in the world. You also served in the IEC, which delivered the first democratic elections of South Africa. We cannot forget that you became a permanent judge the first time in 2001, a Deputy Chief Justice in 2005. Ironically, you then went on to replace Judge Krishna, who you had deputized in the IEC. Even as you became judge, you had succeeded as a litigant in having South Africa's racially discriminatory system of state administration declared constitutionally invalid. This, for me, was the first light that said, indeed, Sikon is caution. Ironically as it may sound, Parliament always values the advice that you, Chief Justice, Deputy Chief Justice, now regularly dish out to us, especially on those cases where we are cited. We listen to your reasons, and we are committed to implement and to honor them. We do so because we understand the role of the judiciary, that it is not only to interpret the laws, but sometimes it is to help us to meander through the processes, the procedures, and the interpersonal relations which sometimes just become too difficult for people who, for whatever reasons, are standing at the opposite sides of the table. So we always want to say to you, do your job independently, do your job, and know that we do appreciate. We appreciate the judiciary because the crafters of our constitution were very clever indeed, that sometimes it is Parliament that thinks it is the balancing leg, but sometimes, and more recently, we have found that the judiciary creates that space to bring us all back together. We appreciate that. And it is also important for us to say that we must not forget as South Africans that Even though we are referred to as parliamentarians, as lawmakers, not all of us are lawyers. There is no requirement that I am a lawyer in the South African system. It is also important to recognize that all judges must be lawyers first. And it is that balance, the fact that lawyers are trained, and in my own Jan Alleman's language, they are the technicians in the field that I find myself in. It is important that I rely that any time they interpret for me and for the general public correctly. So we appreciate that. Moseneke, we are very happy that you've been part of the movement against our sorry past, subjugation, humiliation, whatever. We are even proud that you are part of the democratization of our country. I was told once by Comrade Kenjin so that, you know, judges don't really retire. She said, you know, Mafana Nama Tera, you fire them away until you need to take them out. So in that period of them being fired away, we expect that it is not only your character that you will keep beyond reproach as it is today, and that you will keep your nose also clean, my brother. We hope that you continue, and we continue to seek your wise counsel. We hope that as Parliament, we will continue to look at all the sacrifices, not only of Justice Moseneke, but of all the men and women of South Africa, known and unknown, who have given so much of themselves to enable us to gather here today and to say goodbye to one of our own. We wish you and your family happy years ahead. But I spoke to a few prisoners last night. And they said I should make a suggestion to the retired Chief Justice, Deputy Chief Justice. They said, I should ask you whether you are considering, since one of our own has put a foothold in FIFA, whether you would continue, whether you would consider to avail yourself for the FIFA's disciplinary committee. Because we think they are soon going to need a very serious. And they say that this is because you did admirably well in the Makana disciplinary committee. I thank you, Chief Justice.
Thank you very much, Chairperson. Well, the moment we've been waiting for has arrived. It is now time to hear from the man himself. Over to you, dear.
Chief Justice of the Republic, Moseneke, former President Thabo Mbeki, former President Remekante, indeed President and Deputy President of the SCA, Justices of our court, the Constitutional Court, both current, this sitting and retired, Judges, President, heads of courts and judges of all our courts, members, I could rightly call you comrade, fellow prisoner. Very happy. Deputy Minister, I'll have more to say about you a little later, but thank you. Leaders of political parties and other social movements, all formations within the legal fraternity, deans of law schools, who've been appointed to be here, members of my family, and in particular my wife, Moseneke, and my mother, Moseneke. you so much. Allow me also to welcome all patriots, compatriots, and citizens of our land, and friends who have cared to come and observe this moment with us. I cease to hold office as Deputy Chief Justice of the Republic, and I retire from the Constitutional Court of South Africa at midnight today, the 20th of November, 2016. I've had the distinct privilege of serving the judicial bench for 15 years, of which no less than a continuous period of 14 years in the highest court in our land. A formal ceremony such as the present is by now well etched in our judicial convention. The judiciary knows no better way of celebrating and sending off one of its own than in the very forum in which it dispenses justice. It is a time-honored tradition that on an occasion as the present, fellow colleagues who hold judicial office would row, so would counsel, and be in attendance as a mark of homage to imparting justice. And that explains why, in part, this morning commenced with an actual court sitting in which I had the honor of delivering my last judgment ever in this court. It is a symbolic way of a final salute, or if you want to change the imagery, it is a moment to discard one's robes and gable. In a formal farewell such as the present, I am truly grateful to representatives of the General Counsel of the Bar, Advocate Jeremy Miller, SC. I'm thankful. Just surprised at the amount of research you've done on me. You delivered an eulogy on behalf of advocates of our country. I'm grateful to Mchakazi Mvuso Lutesi, President of NADEL and indeed of the Law Society of South Africa, again representing progressive lawyers in Ireland, NADEL in which I had a part to form, as you know, I'm a founding member of NADEL. So you're in the right space. Indeed, you also represent the Law Society of South Africa, which represents in turn all the attorneys of our entire republic. I'm grateful to you, Advocate Jauke, from the National Prosecuting Authority, that we heard you quite clearly, without fear or favor. In deep recognition that in our constitutional arrangements, the judiciary is part of an arm of the state, a formal ceremony such as the present will be hardly complete without the high representatives and leaders of our legislatures and executive arms of the state. I'm humbled and delighted by the tribute of the Honorable Chairperson of the National Council of Provinces, Honorable Tandi Mudise MP. I was myself afraid that you might go, order. And as you know, my normal gap is that here we don't have to say it. Here we speak one person at a time. And those who are errant, we remind them very quickly that here we speak one at a time. Freedom fighter in your own right, fellow prisoner and a leader. We're equally pleased to receive you, Deputy Minister, Justice and Contemporary Development. You have an incredible mind. You've been one of the consumers and sometimes sharp critics of my judgments and papers. It has been a wonderful intellectual banter you and I have had. that has led to considerable fondness. Because if we were to differ, we differ on a rational plane, mental, not only a rational basis of mere emotions. So really thank you. The rose will find a place of pride in our garden. I'd been forgotten it existed. There was a tribute from some people who thought I deserved to be named after a rose. But thank you so much. I would like to move on to thank deans of law schools. Legal education for young and indeed for sitting judges and magistrates has been my passion. Chief Justice talked a little about it and of the work that we do. The proud judiciary we have is an outcome of hard work to continue to instill and to locate those values in those that hold office so high. And throughout my stay on the bench, I found time to lecture at law schools. Almost all of them I have been, and I see deans of different law schools can attest to that. I'd like to thank you for having given me my intellectual and academic side to find space. And most of the articles that we quoted here were delivered mainly at law schools. And I am grateful for that space, and I thank you for coming out here. All our colleagues in Chapter 9 institutions, continue as you do to protect and advance our constitutional democracy. But you've honored us by being here. I've seen the leader of the Human Rights Commission, the leader of the Office of the Public Protector, indeed of the Electoral Commission, and all of these are very important for who and what we are as a people. I won't spend time today to acknowledge my family. I did that to my heart's content last night. I move on. I have talked a little about my life story last night at the dinner held by the Chief Justice in my honor. I would have forgotten Brati. It's embarrassing. Because it was the naughtiest of all the eulogies. He started by calling me comrade. Indeed, we are comrade in arms in a variety of struggles and battles. And you took the ropes, so did I, in a deep understanding that, as I said last night, there is no real rift between law practice and achievement of justice. In the reason the law is an S, because legal outcomes ought to be just, equitable, not only fair, but they must advance good in society. So they are real Algerians, they are real Kabani, they are real Africa. Now, I've talked a little about my life story last night at the dinner held by the Chief Justice in my honor. I'll avoid doing so again. Mine, of course, is a long tale. I've written up my memoirs. I found somebody to write a foreword, and the memoirs will be published in September of this year. Done. And that tale of my life, of course, meanders from the dusty streets of Richardsville through to my secondary tuition and my untimely residence on Robben Island, when much has been said. Then I had no idea that my perilous experiences would set me up for life of remarkable fulfillment. The pain and adversity in my childhood, methinks, prepared me for a lifelong commitment to conduct that will bring true and full liberation of our land and its remarkable people. The surgeon on Robben Island set me on a course of constantly asking, what are the features of a good society? Out of all that emerged two cardinal lessons. You cannot merely dream about your revolutionary ideals. You have to take real and concrete steps to pursue those legitimate ideals. The second lesson was that I was my own liberator. A line copied from the inimitable revolutionary thinker Anton Moseneke Limbede, and later Robert Mangaliso Sobukwe. They must in turn have copied it from Emile Cabral. These thinkers in essence were urging young people of my time, and indeed of the present time, like me, to pursue inkululeko ngexesha lethu, freedom in our lifetime. And this to me was the ultimate statement of personal and collective agency. We have to identify worthy causes which might change our lot and that of the world, and immediately thereafter we must ask the question, famously asked by Lenin, what is to be done? And then we must get up and do things. Things that will move us closer to our idealized collective condition. So I knew when I came out of Robben Island that I had to make a choice, which Mr. Notesi referred to somewhat, either to go into exile or to remain a combatant in the domestic struggle. I chose to do things the way I know best, to become a lawyer of remarkable excellence, of unfailing integrity, and of commitment to the broader struggle of our people in all their kinds and shapes, in all their colors and origins, for an equal and just society. To that end, I wanted to become an attorney. Even if I was a convicted terrorist, they said. And I did everything to achieve that. I litigated against the Law Society to let me in. They didn't want to. I went on to the Bar Council, which had a race clause that excluded people who looked like me. There too, I kicked the door open, very determined to become a spokesperson of our people in difficult times in that troubled past. I defended every activist you care to remember. I searched and found MK cadres in solitary confinement, protected them and defended them. I saved a number of UPLA combatants from further hangings and executions in Pretoria. I've appeared in trials of Azanla fighters. Few there might have been that were captured and tried. I had the privilege of defending Dr. Fabian Ribeiro, Titus Buffalo, Smangaliso Mkhatshwa, Winnie Mandela, Jan Shoba, Clement Zulu, Ahmad Kasim, Nkosinathi Nhleko, Inwabele Madimane, Zwelakhe Sisulu, Tamima Zwai, Matata Tseli, Ronnie Mamweba, Don Kadimeng, and numerous trade union formations. I had the blessing of a vast, varied and progressive law practice that was well aligned with my personal and collective mantra that I was my own liberator and that our people are collectively their own liberators. Before I knew it, I was senior counsel with only 10 years of practice. at the bar, of course after 5 years of practice as an attorney. Now before the democratic transition gained traction, I made a conscious choice not to be a politician. But to remain a freedom fighter and a revolutionary. What is the difference? There is a difference, and I said it out in my autobiography. But I chose not to be a backbencher, in other words, and to have the free space to be able to move and influence society, to pursue those ideals that are to settle on experiencing. That I thought I could do best by resigning from all political formations and by concentrating on being a full-time legal practitioner. To the murmur of many like Brady, who thought I belonged only in the political terrain. Aside a little digression into business, I concentrated on becoming as good a lawyer and later as good a judge as I could be. There's other justices who pestered me to come to the bench. There's Maruma Mwerani, who made unsolicited calls. But even more emphatic was president of the time, who's here present, Mr. Thabo Mbeki, who in his characteristic way cleared his throat. I would imagine took the pipe out of his lips and went, "Chief, you know," and paused. "You're one of the leaders of our people. You've no business to be in business." Nelson Mandela pursued very much the same way, but he was a little more blunt. And I suspect he was sent on me by the Chief Justice of the time, Arthur Chascosen, and the President of the Republic, Thabo Mbeki. And as I said a little again, he said, Jahan, your people need you. I relented and I became a judge. I didn't quite know that he would come back one day when he was older and said, how will you look after me when I'm no longer on this world? And I said, I don't follow Tata. And he went away, made a will, and said, George Bezos and I should look after him when he's no longer alive. A singular honor. As my mother often says, blessings of the Lord knows no limit. We often say, and the first of the blessings was a near perfect health. You can't have energy in industry if you're not well. I've never been in a hospital to now, except for circumcision. This allowed me the energy to no end, and I thank the Creator and everybody around me that this was possible. And in the 15 years of service, asked the man on my left, the Chief Justice, I've never taken sick leave. And the only time when I was away from work for a week, as I said yesterday, was when my beloved son, Silo Riabetsi, bore us account. So that life, time, dedication to hard work, I brought to my judicial obligations. The second blessing was the love that I've continued to have from our people. work in the supermarket in Pretoria. Môre regter. Dankie vir wat regter vir ons doen. Dankie regter. And you just wonder, what is it? Hey, come here, judge. Sabor, man, come here, sabor. It's that love, endless love that I've shown throughout of this time. And they are entitled to live in a just and socially inclusive society, where their dignity and self-worth is intact and well cherished. They must access quality education. They must access universal and quality health care. They're entitled to clean water, to sanitation, to a place that they can call home, to a habitable environment that is well preserved, and in all this, the space to be simply human. And that explains why, I've said it in other occasions, in my 60th birthday, why people are so central. I'm afraid that is true. They remain central. And I've always felt that is what made me wake up every morning to come here, to come and work, and to be as good a justice as I can, using all that my faculties may permit me. And what a privilege it was to serve you all. And I'm thankful for that. I had no entitlement to that. I had a space to work, to think, to write, to my heart's content. I've had the pleasure of writing on virtually every big political, social, commercial disputes in our land. I've had the joy of going to law schools in this land and in other lands indeed, only to find extensive passages of what this court has written and what I have written, taught to young lawyers at law schools here and around the world. I've been blessed with remarkable colleagues who have made judicial collegiality appear natural and inbred, and they've been part of all of that writing, because we are a college. What you hear us pronounce has been worked on by all 11 of us. It's a collective process. As I end, I go back to where I started. I am my own liberator, and our people are their own liberators. And in the last instance, the people are the bedrock of our democracy. They call the shots, and they decide when to call those shots. And it is they who matter, as we institutions, Parliament, the executive, the judiciary, that will public power make sure that we are in their service. Chief Justice, it was a wonderful experience to work with you. And I hope that I was there to provide you with joint and supportive leadership of our judiciary. I said last night that despite our past uncomfortable encounter, we have found each other. We have made common cause on a principled and honest footing. We share the love for our people and their right to be well, as much as it is our duty to serve them. And I say without any fear of contradiction that your integrity has been shown to be beyond question. Your fervor to defend and protect the gains of our hard-won struggle for liberation, freedom and democracy is now unsurpassed. Each time there was a storm that swelled around our institution, you and me stood firm and together. You never flinched from making unpopular decisions. provided they were consistent with your honest and rigorous judgment, Chief Justice. But sadly, much turbulence lies ahead. But that is what good pilots learn to live with. I'm happy to tell our nation you are a safe pair of hands, and I wish you well as I make my last salute to you. I always understood that everybody exercises in public power, and you do so within the constraints of the law. I knew well that uncomfortable as it often was, executive and legislative and indeed corporate and business excesses had to be curbed. I truly hope that I was faithful to my oath of office. And I pray that I kept the high standards and traditions of judicial excellence. To my remaining colleagues, in this court and all our judiciary, I urge you to remain on this hallowed bench, not unaware of what a privilege it is. You must recognize that you may be important, but in fact you're standing on the shoulders of giants. You must promise that you shall remain true and faithful to all that you have been. You must promise to defend fearlessly the independence of the judiciary, the rule of law, and more importantly, the full realization of the basic rights our Constitution affords to our people, and particularly excluded, marginalized, and vulnerable. You will be very much part of the transformation enterprise. It's not something out there, it's something what our nation is about. We have to move from the awful spaces to better places. You will be part of the democratic project to make our country reflect the text and the living spirit of our Constitution. Fidelity to oath of office is important, not because we are important, but because without it, not us, but our people will suffer. Our people are want to add again in these stupid times. I mean the full diversity of our people. Poor and rich, black and white, female and male, urban and rural, immigrants, vulnerable people, the marginalized, the disabled, and indeed powerful ones, all deserve our unwavering protection, which our Constitution demands us to provide. After all, you judges are the ultimate guardians of our Constitution for and on behalf of our people. May God bless Africa. May God bless her people.
I take this time just to thank everybody for having helped make this day as memorable as it should be and as memorable as it has turned out to be. But but for your presence, but for your support. Justice would not have been done to the legacy of Deputy Chief Justice Dikgang Moseneke. We're very grateful to you, all of you without exception, to the members of the media for your support. When I say Omokholo, I mean two things, not only just my elder brother, but also the great one. That's what it means, Omokholo. Because indeed, Omutu, Omokholo, you are a great human being. You have been an exemplary leader. I have no doubt that you will have done. A party short is this: there is lack of understanding relating to what is it that judges can say, particularly outside of their judgments. Are they permitted to talk about the hunger of the people as you have just said, or not? Please make it added to the menu that I humbly dished out to you yesterday. Add it to the list. Help educate our people. Are judges permitted to speak on public platforms in the first place? And if it is permissible to do so, on which societal issues are they not permitted to speak? Are they permitted to say anything about racism? Are they permitted to say anything about the land? Are they permitted to say anything about the economy? Are they permitted to say anything about peace and stability? What parameters are there, and what is the ethical or legal foundation for the imposition of those parameters? It's important because it will help to lessen the tensions that inevitably arise out of lack of understanding. We will miss you for a number of reasons. Some of them is because of your deep pocket that I often tease you in our private space, and never forgetting that we always have to be as sober as a judge. It is DM, our entertainment allowance makes no provision for those things that could challenge your sobriety. And it is DM who would just generously go out of his way to buy those drinks. What do you call them? You and good 10 minutes per year said, waters of what? Waters of immortality. But rest assured, all leave my official residence being sober. We will miss you, dear. Thank you very much for the colleague you have been. And this marks the end of the session. Before the court adjourns, there are some refreshments out there. I hope there are enough for all of us. But there are refreshments. Let it not turn out to be wasteful expenditure. The court adjourns.